We're live.
Okay, good morning. This is April 11th, Friday, April 14th, 2023. And we are taking up first H45, an act relating to abusive litigation filed against survivors of domestic abuse, stalking, or sexual assault. Our first witness is Michelle Childs from the Office of Legislative Counsel, who will do a walkthrough of the bill, describe what this 11-page bill does or doesn't do. Looks like it's almost all underlined.
You are correct. So good morning. H45 is passed by the House. It essentially creates a new subchapter. So you're right, everything's underlined. It's all new law. Creates a new subchapter within our abuse prevention chapter that is in Title 15. And this new chapter establishes a procedure to allow survivors of abuse to request a court order to restrict the abuser's ability to file new litigation against the survivor. So I'm going to walk through the bill. I'm going to share my screen. Can everybody see that all right?
Mm-hmm.
And, you know, usually I don't go kind of line by line or go too much during the initial walkthrough about this, but it really is, it's pretty heavy in the court procedure, and I am gonna just do a little more reading of the exact language that I typically do, so that we can really kind of focus in on this. So you'll see Section 1, as I mentioned, it's creating a new subchapter within your abuse prevention chapter in Title 15. And we're going to start out with the definitions, starting out with the definition of abusive litigation. So abusive litigation means, and you'll see there that the opposing parties have either a current or a former family or household member relationship. So remember, when we talk about family or household member, those are folks who are able to get abuse protection orders under Title 15. So it's they have either a current or former family or household membership relationship, or there's been a civil order or a criminal conviction determining that one of the parties stalked or sexually assaulted the other party. The next is that the party who is filing, initiating, or advancing the litigation has been found by a court to have abused, stalked, or sexually assaulted the other party. And these are the ways in which that can be shown. You'll see big I there. It's a final order issued pursuant to Subchapter 1 of this subchapter. So there's been an APO issued. The next one is that it could be a final order issued pursuant to your Title 12 provisions around orders against stalking or sexual assault. So those are the ones that apply that where you don't have to be a family or household member. Page 2, evidence could be shown by the issuance of a final foreign abuse prevention order. So just meaning, you know, it's something similar to what we have in Title 15, but it was issued in another jurisdiction. It could also be shown by an order under Section 665A of Title 15, which are the conditions of parent-child contact in cases of domestic violence. There's a specific statute there that affords a different approach when there has been domestic violence within a family and they need to do a parent-child contact order. The next one is you could show this relationship according to a conviction for domestic assault or for stalking or for sexual assault. And then the last one is that you could show that there's a court determination of probable cause for a charge of domestic assault. So there has not been a conviction, but there was probable cause found for an assault, and the court imposed criminal conditions of release pertaining to the safety of the victim in that particular circumstance.
I have a question about that.
Sure.
Don't we have a presumption of not guilty until there's been a trial? So there's been a determination of guilty.
That is certainly true. I think, you know, this is a policy decision for you, whether or not you would want to include that particular one. Again, we're talking about whether or not you would qualify to ask for a restriction on litigation. Pardon?
Yeah, Michelle, I certainly listened to the testimony, but I hate to put into law where someone has not been found guilty of an offense.
Okay, sure, I'll take
note
of that.
I don't remember doing this elsewhere where somebody has not been found guilty.
Can I, well, I mean, you know, I
We
think,
take away firearms, we do other things.
yeah, I think, you know, one example is to think of, you know, TROs, you know, you have, the other person isn't guilty, but
Yeah,
you're filing the abuse prevention order or the temporary restraining order, and it's subject to a hearing later on.
right.
And in this, at least from what I'm reading so far, it's the goal would be to prevent somebody from filing multiple lawsuits
Correct.
after they've been charged or probable cause has been found. So it wouldn't restrict their liberty or their, you know, freedom of movement or anything like that. Just what they're able to file is my understanding so far.
Yep.
Which wouldn't prevent them down the road, like if they're found not guilty, of later filing some sort of suit, right?
Right. I mean, I think maybe once I go through the whole process and you can kind of understand what this is a qualifier for, it might help. But it is strictly it's policy for you to decide whether or not that meets your standards. And then the next requirement under abusive litigation is that the litigation is being initiated, advanced, or continued primarily for the purpose of abusing, harassing, intimidating, threatening, or maintaining contact with the other party. Then we move.
Michelle,
Yep.
I had some questions on that part, and just let me know if it'll become clear later on. But you know, obviously, when somebody files a lawsuit, their complaint isn't going to, you know, outline that the purpose of it is to harass or maintain contact with the other person. So how does this little section right here work exactly?
We're going to get there. There
Okay,
are factors
thank you.
that are identified in here and that help guide the court in determining whether or not that's the purpose of the litigation.
Thanks.
Yep. So the next one is also that at least one of the following factors apply. The claims, allegations, or other legal contentions are either not warranted by existing law or by a reasonable argument for either extension or modification of that law or adoption of new law. Or it could be that the allegations and other factual contentions made in the litigation are without adequate evidentiary support or are unlikely to have evidentiary support after a reasonable investigation. Then top of page 3 is an issue or issues that are the basis of the litigation have previously been filed in one or more other courts or jurisdictions, and those issues have already been litigated and disposed of unfavorably to the party filing, initiating, advancing, or continuing the litigation. Okay, I'm gonna move on through. Foreign abuse prevention order is just what we use currently in Title 15 in the abuse prevention chapter. Subdivision 3 just identifies the types of litigation that might be involved. And then top of page 4, when we're talking about the perpetrator of abusive, I'm sorry.
And 2, probably add the Virgin Islands. You've got Commonwealth of Puerto Rico, District of Columbia. I think you should
Okay,
add.
I will take a look at that. That might be something, because this is a definition that's used in multiple places. It might be something you might, I mean, we could do it in here, or you might want to put it in
That's the
miscellaneous.
U.S. territory about 40 miles from Puerto Rico.
Don't we
Yeah,
also have
considered,
Guam and American
but-
Samoa?
Pardon?
I said, don't we also have Guam and American
Yeah,
Samoa?
we do. Yeah.
I mean, I don't know what is a territory or possession of the United States. They don't fall under that currently.
Well, I think we should look at that. There are people who come from Guam who live in Vermont. There are people from the Virgin Islands who live in Vermont. There are people, I know one of the people from Guam.
Okay, so I'm on page 4.
Yep,
So now we're going to get into section 1182. So a party can request from the court an order restricting abusive litigation if, and this is a kind of a restatement of the definition of abusive litigation. And so you have the criteria in here, and it's a little repetitive, but it's basically kind of repeating what you have on the definition of it and the conditions of what qualifies as abusive litigation. You see on page 5 on subsection B. So a party who meets the requirements of subsection A can restrict an order, can request an order restricting abusive litigation in the following types of cases. So in any answer or response to litigation that's been filed against them by the perpetrator of the abusive litigation, by motion made at any time during any open or ongoing case, in any answer or response to any motion or request for an order, or orally in any hearing. And then once that request is made, then you'll see subsection C, court may on its own motion or on the motion of a party determine that they need to hold a hearing to determine whether or not it is actually abusive litigation. Subsection D is that proceedings can be initiated by petition instituting either a new case, or if there's an ongoing case, it can be by a motion in the pending case. Top of page 6 is just subsection E is that the court administrators to create some forms for this. Subsection F is that no filing fee is charged to the unrestricted party. And subsection G is that the provisions are non-exclusive and don't affect other remedies. So section 1183 is the hearing procedure. So at the hearing, evidence of any of the following that I'm going to go through shall create a rebuttable presumption that the litigation is being initiated, advanced, or continued primarily for the purpose of harassing, intimidating, or maintaining contact with the other party. So Senator Hashim, this is where the factors that the court would consider. So the first one being that the same or substantially similar issues between the same or substantially similar parties have already been litigated within the past 5 years. So it's kind of like you don't have the opportunity to just rehash stuff that's already been hashed through. Subdivision 2 is that the same or substantially similar issues between the same or substantially similar parties have been raised, pled, or alleged in the past 5 years and were already decided on the merits, or they were dismissed. So these issues have already been before the court, and this person is bringing them back again in front of the court. That can be used as for evidence of it being abusive litigation. The next one is that within the last 10 years, the party allegedly engaged in abusive litigation has been sanctioned by a court for filing one or more cases or petitions or motions that were found to be frivolous or brought in bad faith involving the same opposing party. So you have the two parties, and the person has already who's filing has been found by a court to have been filing frivolous litigation against the victim.
what is vexatorious?
I remember,
Well,
I have it in my notes.
It's the second line for word.
Right.
What is it?
I'm gonna have to Google it. I think I have it in my notes, but I think it's the
Must
same
be
thing.
really bad. I've never heard of it.
I mean, Michelle's Googling it. I think maybe lots of people have never heard of it.
Causing or annoyance, frustration, or worry, vexatious.
Oh, so it's just a different form of vex.
Maybe we should describe it a little. So, I mean, of course, I can't imagine. No, I can't imagine, but I've never heard that word before.
I have heard it like vexing, like, like troubling.
Yeah.
And then subdivision 4 is a court has determined that the party allegedly engaged in abusive litigation has previously engaged in abusive litigation or similar conduct and has been subject to a court order that has imposed pre-filing instructions. So moving on to section 1184 for burden of proof. It's preponderance of the evidence standard. And if the court finds preponderance of the evidence that a party is engaging in abusive litigation and that any or all the motions or actions pending before the court are abusive litigation, the litigation is to be dismissed, denied, stricken, or resolved by other disposition with prejudice, meaning that they can't then bring it back before the court. Subsection B in subdivision 1 is that after providing the parties an opportunity to be heard, the court can enter an order restricting abusive litigation that may include conditions that are deemed necessary and appropriate, including awarding the other party reasonable attorney fees and costs. 3 is identifying the party protected by the order and imposing pre-filing restrictions upon the party found to have engaged in the abusive litigation. Page 8, subsection C. If the court finds that it isn't abusive litigation, then the court shall enter a written or oral findings and the litigation shall proceed. So there's the process there of if it's found to be abusive litigation, there's a restriction placed on the perpetrator of the abusive litigation in terms of filing a new case or a new motion, but it's not absolute. They still have the ability to do something, but they have to be permitted by the court to move forward with something once there's been a finding of abusive litigation. So section 1185 is if that person wants to file a new case against the survivor. So subsection A is that a person who's subject to an order restricting abusive litigation is prohibited from filing or initiating new litigation for the period of time that the filing restrictions are in effect. If those restrictions have been imposed and they want to initiate a new case or file a motion in an existing case, while that restriction is in place, then they have to apply to a judicial officer. The judicial officer is to review the application and determine whether the new proposed litigation or motion is abusive or if there's a reasonable or legitimate grounds for allowing them to move forward with that litigation. And then the judicial officer determines whether or not a hearing is necessary to make that determination. Page 9, subsection C. If the judicial officer determines that this new proposed litigation is abusive, it's not necessary for the person protected by the order to appear or participate in any way. If the judicial officer is unable to determine whether it's abusive without hearing from the person who is protected by the order restricting the filing of a new case, then the court issues an order scheduling a hearing and notifying the protected party of their right to appear and participate in the hearing. There is a provision there, see the last sentence, that when possible, the protected party is permitted to appear remotely. Subdivision C2, if the judicial officer believes the litigation that the party who's under the pre-filing restriction order is making will constitute abusive litigation, then the application is denied. And it is dismissed with prejudice, so they can't bring it back again. Subdivision 3, If the court thinks that it's not abusive litigation, then the judicial officer can grant the application and issue an order permitting the filing of the case or the motion or the pleading. Top of page 10, subsection D. The judicial officer has to make written finding, or not written, make findings and issue a written order supporting the ruling. If the party who is subject to the order disputes the finding, they may seek a review of the decision as provided by applicable court rules. Subsection E, if the application for the filing of a pleading is granted, the period of time commencing with the filing of the application, requesting permission to file the action, and ending with the issuance of an order shall not be computed as part of any applicable period of limitations within the matter in which it has to be initially instituted. So that kind of gets deducted. Subsection F, if after a party who is subject to the pre-filing restrictions has been granted to file or advance a case, if the judicial officer determines that while that new litigation is going on, that the person is attempting to either like add parties or amend the complaint or alter things in a way that would then constitute abusive litigation, then the judicial officer is to stay the proceedings and refer the case back to the judicial officer who granted the original application to file. So it's kind of like you've been granted, the person's been granted permission to move ahead, but then if they subsequently make motions or change parties, things like that, and it starts to turn into abusive litigation, then it goes back to the judicial officer that had initially granted the party the ability to pursue the litigation. Subsection G, this just is like procedural stuff, is that if the party who's protected is served with a pleading that's filed by the perpetrator of the abusive litigation, and they don't have a copy of the order attached, the protected party can respond to the case by filing a copy of that order that shows that the person is restricted from filing against them. Subdivision 2, finally, is if it's brought to the attention of the court that a person against whom pre-filing restrictions have been imposed has filed a new case or is continuing in an existing case without having been granted permission to do so, then the court is to dismiss, deny, or otherwise dispose of the matter. And the court can take whatever action against the perpetrator of the litigation deemed necessary and appropriate for violating the court's order. And the act is to take effect September 1st of 2023 to give the bar and the court as well some time to gear up for these types of motions. So again, it's, just kind of reviewing a little bit, you have to have the, the certain qualifiers, and there has to have been a finding that that one party has abused or stalked or sexually assaulted the other party. They go before the court. There's a determination based on preponderance of the evidence whether or not the litigation is being filed for the purpose of intimidating or harassing the survivor. And if that is found, that the court finds that it is, then there's a restriction placed on the perpetrator in terms of filing new litigation against the survivor. And then going forward, if the perpetrator of the abuse wants to file new litigation against the survivor, they essentially have to get court permission or court clearance so that the court is assured that the purpose of the new litigation is not to further harass the survivor.
Okay.
Senator Hashim, did I mostly answer your question there? I know we'll hear a lot from the witnesses.
Yes, you did. Thank you.
Okay,
Thank you, Michelle.
sure.
Our next witness is Aaron Jacobson of the Attorney General's office.
Good morning, Chair Pierce. Good morning,
Morning.
Senators. For the record, Erin Jacobson, I am an Assistant Attorney General and co-director of our office's Community Justice Unit. The Attorney General's office supports age 45, as you likely know. Helping mitigate the problems of domestic violence in Vermont is a major priority for the Attorney General, and we see age 45 as contributing to helping deal with problems of domestic violence, because abusive litigation is just yet another tactic that abusers can use to coerce and control their victims. A lot of work went into this bill, and we believe that the version before you strikes a good balance between providing the courts with a tool that can help protect survivors from abusive, controlling, and frivolous litigation, and from our courts being used for such purposes, while also protecting important constitutional rights and proper access to the courts. So stakeholders had a good constructive process when this bill was in the House. We worked together to find the right balance. And crucially, testimony in the House included the voices of survivors and their advocates, from whom I know you will also get to hear today. And then the office, our office, the network, and the judiciary all work together with lawmakers and Attorney Childs to help iron out some of the concerns when we were trying to strike this balance, and to craft the bill that is before you this morning. So some of the concerns that we were trying to address and that we were all contending with were as follows. For one, questions were asked, and we considered whether this bill is even necessary. After all, the Vermont Rule of Civil Procedure 11 requires that litigation cannot be used for improper purposes, such as to harass or to cause delay or needless increase in the cost of litigation. Rule 11 also mandates that all filings must be non-frivolous and supportable by evidence. So that Rule 11 essentially is something that also provides the kinds of restrictions and protections that this bill is trying to provide. But as we heard in the House, and as you will likely hear from witnesses, Rule 11 is simply not providing relief from the kind of vexatious litigation that survivors are really experiencing. And it's not really being consistently applied or properly used, especially by pro se litigants, which is understandable. But oftentimes in the kinds of cases where you see abusive litigation coming up, there are also pro se litigants many times on both sides. And so this bill provides some more clarity and a good framework for dealing with the problem that survivors are facing. We also considered the important constitutional concerns at play here, as I mentioned, namely due process, First Amendment, and access to justice. Again, we all work together to ensure that any relief this bill would provide is not going to negatively impact another party's rights. And in thinking about that, and certainly Judge Zone can speak to this, I'm sure, much better than I can, but we considered two related Vermont Supreme Court cases, Zorn v. Smith and Fox v. Fox. And in those cases, the court was trying to balance the interest between a litigant's access to the courts and the interest in protecting opposing parties and the courts from vexatious litigation. So the same thing that we're contending with here. And Fox v. Fox was a case that was between a mother and a father, where there was a lot of litigation surrounding the children, and in which the court determined that the record reflected that fathers' multiple filings were often frivolous, and that in fact, there was evidence to support the finding that the father was filing these pleadings specifically to harass his, the mother of his children, of their children. So Fox v. Fox was involved in a situation very much like what H45 contemplates. And so in determining whether the lower court had properly issued pre-filing sanctions against father, in other words, that the lower court had determined that the father's past filings had been frivolous, and so issued a sanction saying, okay, that's enough. You are not going to be able to file any further filings against the opposing party. The court had to determine whether those sanctions were appropriate. And in so doing, the court weighed several factors that actually flow from a Second Circuit case. And those same factors were applied in the Zorn case. And yeah, go ahead.
What was the Second Circuit case? Do you have it?
I have it in here somewhere. Can I get back to you?
Yeah,
Yes,
no,
I will
thanks.
certainly do that.
That'd be helpful if we could have copies of your testimony.
Sure, absolutely. And that will have the case citations as well. So Fox v. Fox was trying to determine whether those sanctions were appropriate and applied certain factors. And those factors included whether the sanction was narrow enough, specific enough, such that the sanctions did not impede on the litigants' due process rights, but also did the sanctions protect the opposing party from the abuse of litigation and deter future abuse of litigation. And in that case, the Supreme Court held that those sanctions were proper and in the proper discretion of the court. So essentially, that case law and its constitutional underpinnings is the framework for this bill. And we think that because there's a lot of clarity in this bill, although it might seem complicated on paper, it actually provides a really good roadmap for how a survivor might get protection from abusive litigation, while also providing clarity and constitutional protections like access to the courts. So with that, we support this bill, and if anyone has any questions, I'm happy to answer.
Thank you. I guess the only question I have is regarding standard of proof, ponderance of the evidence.
In that section where
Should
you,
not some other standard clear and convincing.
and are you, oh, I thought you were talking about your concern regarding section
Well, that
on page 2.
I was gonna hold off until I heard, I am concerned about 2. The court determination of probable cause for charge of domestic assault. The court imposed, so the person hasn't been found guilty yet. The second place where probable cause comes the burden of proof on page 7.
Oh, yeah.
I don't have line numbers, but it's 1181A.
Mm-hmm.
So we're using burden of proof rather than clear and convincing, which would be normal, I would think, in some of these cases, particularly where the person hasn't been convicted of a crime yet.
So I think in terms of I'll start at the earlier part of the bill. Your first question that you asked when Attorney Childs was testifying about whether this person has actually been convicted or found guilty. This is really just a limiting factor for who could actually be subject to a sanction for abusive litigation. We don't want this to apply to just everybody. And if a court has already imposed criminal conditions of release pertaining to the safety of the victim, there is evidence on the record and at the court hearing that there's good reason for those conditions. So it's not, I don't think that there is some kind of due process problem there, because there's clearly already evidence that the victim needs to be provided protection from that particular individual.
No, Senator Booth.
I missed the walkthrough on this bill, and our attorney isn't here, so I was going to ask your opinion of this because.
She's online.
Oh, hey, Michelle. I'm just going to ask Aaron a question about the bill. So you said that this was complex on paper, but it provides a clear roadmap. I find this chain on page 1, the definition, incredibly confusing
Okay.
and productive of unnecessary confusion. So it says abusive litigation means litigation where the following apply. I read that as where all of the following apply. But then when you get to the bottom of the list on 2, there's an or. And then it's unclear to me whether that means, and so that or touches off a series of ands, and then is followed by at least one of the following factors apply. So there's like 3 different lists with ands and ors, and it's unclear to me. It's like a choose your own adventure. I don't understand how someone with any real clarity determines what the necessary factors are. Is it one of the first list and then one of the second list and then at least one of the following factors apply, or?
Oh, boy. Okay, I'm just trying to make sure I'm tracking your question.
Yeah.
Keep going.
So
Yes.
you see my
Yeah.
confusion?
Yeah.
I'm
I mean-
assuming lawyers have like mathematicians have an order in which things happen, and so
Yes.
you read it more clearly than I do.
So my take on this is that there's a lot of different situations
Yeah.
in that wherein abusive litigation might be arising.
Yeah.
And this bill in particular is aiming to protect survivors of domestic and sexual
No,
violence.
I get
right?
that. I'm just talking
Yeah.
about the mathematics of it here, like, or not mathematics, but the schematic I'm trying to follow. It says where the following apply.
Right, and those are like pertaining to the parties, right?
And so that first list has a series of options, and under Roman numeral 5, there's an or. So do you need all of those things above? Do you need all of the things on the list that begin on page 1, or you just need one of them?
You just need one of them.
Okay, and then when we get to the or, is that I'm confused about the relationship of the things following the or to what comes before. Then I get further confused down below when you have to have at least one of the following factors apply.
Okay, so my take on this, my read on this is that the first part of this bill, in
Yeah.
talking about abusive litigation, 1A is talking about the parties,
Okay,
right? So the relationship between the two people is important here because we're talking about domestic or sexual abuse,
Mhm.
right? So this could be evidence that they have this kind of intimate partner relationship. And then likewise, so it could be one of those kinds of things. Or it could be that there's some kind of determination of probable cause in a charge of domestic assault, which is still getting at that intimate partner relationship, in which you wouldn't yet necessarily need there to be a conviction at the time, but there's some indication that the survivor needed protection levied by the court. So again, I think all of those are getting at, is there this intimate partner relationship or
Right.
violence?
and when we say all of those,
Yes.
it
Any
varies
one
my
of those.
question again. Because when we get to page 2,
Mhm.
and we're down about line 6,
Mhm.
there's an or. At the end of Roman numeral 5, there's an or. then
Yeah.
the next one has an and
Yeah.
and, followed by at least one of the following factors.
Right.
So is everything following the or creating one more in the sequence that governs the parties? I just find this
So-
impossible to follow.
Okay, well, that, maybe this is something we could work on with Attorney Childs, but I would just say that I think the whole first 1181 subsection 1, all the way down to that till the and,
Yeah,
is if you have any one of those pieces of evidence about
Yeah.
that there's this intimate partner relationship, you can check that box, right? Like,
Okay.
these are the two parties this pertains to. And then if you have that, you've got the two parties with their intimate partner relationship that's abusive. And then you would also have to be shown that the litigation is being initiated primarily for these nefarious purposes. And at least one of the following other factors.
oh,
specified.
okay, and this is the last I'll say on this. So under Roman numeral 6.
Yes,
That is one more in the list, but it apparently that Roman numeral 6 is constructed of that paragraph and the following one, and at least one of the
Yeah.
factors. It's unclear to me whether at least one of the following factors has to apply to any of the previous lists.
Judge Zone
Or
said
just-
that he would answer the question.
Okay,
Okay.
great.
I guess he's also intimating that I'm not doing a good job of answering, and I apologize.
No,
I'm
But
just,
I appreciate that, Judge. So again, I just think there's different factors that must apply. One has to do with the relationship between the parties, and
Yeah.
then the other has to do with why the abuser is initiating this litigation. And then the last one has to do with factors about the litigation itself, that it's not warranted, that it's entirely frivolous.
I agree that it's confusing.
yeah,
Maybe it's because we're not attorneys, but
Well, you shouldn't have to be
trying
technically to
to-
understand our laws.
if you're pro se,
Appreciate
trying to
that.
figure out what you can and can't do
Right.
may be difficult with this kind of definition.
Right, and laws
We
should
are
be
writing
written for
a new
everyone, not
chapter.
just lawyers.
We are writing a new chapter 21 with this subchapter, chapter 21, and it's all new. So all the language is new, and that provides us with that opportunity. But I'm gonna ask Judge Zone, he's our next witness, and what I'm gonna do is after Judge Zone is ask the impacted citizens to speak, because I don't want, we may not get to everybody today, and I'd rather hear from the impacted citizens today, so that they don't have to come back.
Okay, good.
thank you.
Okay.
Judge Zone?
Good morning.
Morning.
Tom Zone, Chief Superior Judge. No, I was not
Glad to
commenting
see
that
you
Ms.
all.
Well, that's the goal. It's Friday. We're always open on Fridays. So when I indicated that I'd be happy to weigh in and answer this question, it was not a criticism of Ms. Jacobson at all. It's just that I see the issue. And I think that unfortunately, sometimes when we look at the way statutes are put together, there's that lawyer judge side of things, and it's not the clarity that we would like is not always there. But Senator Bruce, let me try and address your inquiry. The structure is, as I read it, the abusive litigation means A, litigation where the following apply. Now, the small I, think of it as factor 1. So that has to apply, small I. And then the small I is really factor 2. Factor 2 has 6 potential subsets that can be met for factor 2. They do not all have to be met, but factor 1 has to be met, and factor 2 with one of those 6 subsets have to be met. That's why there is the or after number 5. Roman numeral 5 on page 2, because one of those 6 has to be met.
Yeah,
And at the end of Roman numeral 6 is really the and, and bringing in factor 3, which is the small I, which is the next factor that must be met. Does that make sense? And that's A.
yeah. I
And
think I
then-
follow.
And then B,
Finally, at least one of the following factors.
yeah, and then B, what happens is another, that and at the end of 3, that brings in subsection B as you have to meet at least one of these other factors too. What,
Okay, in terms of B, at least one of the following factors apply. That's confusing to me because well, anyway, I see, I have much greater clarity after that explanation. Thank you.
but as you know, as I was listening to the discussion, I do think that, and I'm in my mind running through some ideas on how to add greater clarity, and I think if I can possibly touch base with Ms. Childs and other stakeholders to maybe try to address that. There may be some ways to clarify it a little better.
Thank you, that would help.
Michelle, you wanted to comment on that?
I just want to jump in and we can take a look at this, but I think Judge Zone did add some clarity there, but I just want to point out that when you're looking under subdivision 1A II, those are examples of what you can use to show that the person filing the litigation has abused or stalked or sexually assaulted the plaintiff. So you're using that as evidence to show that relationship.
Yeah.
And so
Yeah.
that's why there's the list and the or, but there's the 3 things that you have to show under 1A. And then you have to have one of the things under B. And I understand it's hard and we can work on it and stuff, but it is tricky in the sense that it's like you have to have these factors, you know, and there's a list and there's a lot of options, and it is a bit of a choose your own adventure. There's a lot of ways you can get there. And so you know, we can play around with it, but I could also create you a cheat sheet for what it means.
I do agree with Senator Baruch in that you read the definition of abusive litigation, it starts with abusive litigation means, and then it's all that. Then over on page 3, it says litigation means any kind of legal action proceeding. It's a lengthy definition.
And Senator Sears, this gets to, I think, also your question when you asked the question about conditions of release.
Yeah.
The factors that are set forth, as I understand it, and I'm going to be very clear, this is a policy bill, and the court's involvement was to help to try to add clarity where we can and to add clear and understandable procedures so that as this bill is utilized and understood by not only the individuals who are seeking its protections, but the individuals against whom it would be utilized. And for the judiciary, it's important that we really tried to effectuate what we understood to be the intent. And the intent ties into your question about conditions of release, because the intent, as I understand it, is that the individuals who are seeking this type of protection come before the court in a number of ways. And the best example I could give is a situation where there may be an incident between a couple, and the woman goes and gets a relief from abuse order, and then she gets a final relief from abuse order, and there's also criminal charges that are filed. In those circumstances, if there is ongoing parental rights and responsibilities cases, And there's let's say the gentleman keeps filing claims against the individual. Well, the woman could file under this statute because there is a final order issued pursuant to the abuse prevention. And so that would give the leg up, if you will, there to be able to file. But what we see sometimes in the judicial system is that someone may get a temporary order of protection. And then the individual is brought in on criminal charges, and there are conditions of release imposed that have distance restrictions and or prevent contact. And the victim in those circumstances will sometimes say, I don't want to go through a hearing to get a final relief from the abuse order. There's a criminal conditions of release that provide me protection, and they don't want to go through to get that order. This section about the conditions of release, as I understand it, was added so that the victims in those circumstances would not feel obligated to have to get that final relief from abuse order to take advantage of the opportunity presented by this statute. In other words, if that section were taken out for probable cause, the individuals would still be able to potentially get this order by proving a preponderance of the evidence at a relief from abuse hearing to get a final order. So,
Let's hope.
it was added for that reason, as I understand it.
But all of this is confusing, and I'm wondering why we don't just amend Rule 11.
Well, Rule 11 is a rule that is of general applicability in all cases. It's for all civil cases, which then can come into family cases also because of the cross-reference in the family rules and the rules under relief from abuse orders. It is a rule that generally has been involved with attorneys. And it's the rule that is generally, well, you need to withdraw that claim because it's not a good claim, and there's a process that you have to give the party an opportunity to withdraw it. The states that have introduced this type of bill, as I understand them at this time, would be Washington, Idaho, and Tennessee. My understanding is from discussions I've had with colleagues in Washington in particular, was that it was in those states viewed that Rule 11 didn't really work as well to address domestic violence situations where the litigants may not be aware of what the rules of civil procedure were for Rule 11 and how to avail themselves of it. And having a rule that was clear, that set forth a definitive framework on how people can get protection in certain circumstances, was viewed to be preferable to trying to go in and change Rule 11, which is a rule that is across most of the states in our country have some variation of the federal rule of civil procedure 11 and how we have looked at it. And so it would really be taking a change in Rule 11 that I think the drafters of this believed it was more important to try to address what this is really trying to address in a specific statute, and that was matters involving domestic abuse and domestic violence, and the courts being weaponized potentially by repeat filings, vexatious filings, which I'll take the hit on that one. There are 107 cases in the state of Vermont where the Supreme Court has used the word vexatious. There are 14 rules where we use that word. And there are 3 statutes that are enacted, I believe, if my research is correct. And it all has to do generally with attorneys' fees and sanctions. And so that's a term that is used in the courts. But
is that in the bar exam?
If I can assure you, had it been in the bar exam, I probably would have missed that one and gone back and go, oh, now I learned it.
Senator, she will be able to.
Yeah. Taking notes from multiple reasons.
So while Rule 11 has been used, and Ms. Jacobson is correct, there's been 2 cases where the Supreme Court has looked at this. The case involving Zorn was not a domestic case. The case that she referenced, the Fox case, was a domestic case, and the court did utilize Rule 11. This bill, in many ways, and I think Ms. Jacobson mentioned this, tried to take what was really in those decisions and put it into a statute that the drafters and the House believed would meet the constitutional rights that individuals have. And the Vermont Supreme Court did note in the Fox case that there is a right, fundamental right, to be sure, of access in the courts, but that right is not absolute, and that there can be reasonable restrictions with precise sanctions and precise requirements put in. And in the Fox case, for instance, the Supreme Court sent the matter back to the trial court because it didn't have a process for that individual that of sufficient clarity to be able to know how he could make continued filings with the court. And this bill that H45 sets forth the standards as to who it applies to, how you seek the matter to be going forward, the standards that are going to be applied, and as I think Ms. Jacobson said, it thereby seeks to preserve the due process rights of the individuals. And so I note that in the House, there was some talk about how many cases will this apply to. And I can say that there may be differences of opinion on that. My view is that it is for the extreme cases, and I don't think it's going to apply to hundreds of cases. I think it will be a dozen or more, something in that type of range. It's more towards that end, I think, than the high numbers. And so,
How long would it take an impacted citizen to get through the court process?
on
Under
this, it's tough to tell, but if this case came in, I would imagine within, my hope would be that we would take care of this type of filing within 30 to 60, well, within 60 days would be my expectation, that we would hopefully be able to get these cases in, because it's an important case for the individuals who are filing for protection. And it's an important case certainly for the individuals who believe that they have a remedy in court and for the court to address it. So these are cases that we need to get in, and I would, if this is passed and signed into law, I would make sure that the judges knew that when these, and the clerks knew that when these cases come in, we have to prioritize them.
Good. Other questions for Judge Zelnick? Judge, thank you very much.
Thank you. Have a good day.
Our next witness will be Brianna Yarnell. Good morning, Brianna. I'm Dick Sears from Bennington County.
I'm telling you, nice to see you, Brianna.
Bob Morris, Franklin District.
And Phil Bruce Central.
Not a shame, Wyndham County.
Chittenden Central.
We're Chittenden centric here. Two members, South. Chittenden South,
Chittenden
Central.
Chittenden Central, excuse me.
Don't mix us up.
Mm-mm.
I'm good with that. Phil, I look at that and I'm good with it.
Okay, sounds good.
Good morning, committee. My name is Brianna Yarnell. I am a native Vermonter and a survivor of domestic violence. I am testifying today in support of H45 because of my lived experience navigating the court system after abuse. My experiences within the Vermont court systems began in March 2011. I was a 21-year-old brand new mother to my then 8-week-old son. In the weeks and months that followed my near fatal assault, my son and I experienced temporary homelessness, food insecurity, and an uncertain path forward. I was stalked, raped, and forced to send my infant child for unsupervised visits with my abuser. Most of all, I lived in constant fear. Even with a protection order in place, I did not trust that my son and I were safe. By fall 2011, my abuser persuaded me to drop my protection order and to sign over and agree to shared custody. Then he filed in court for sole custody. For months, I was harassed, stalked, and recorded without my consent. I scrambled to hire a lawyer for what little money I had, which ultimately did not serve me well. I was advised that he would win because he was intentionally unemployed, but I worked 50 hours a week trying to provide for my son and I. So we agreed to a renegotiated shared 60-40 custody agreement. Ironically, I lost my job shortly thereafter due to missed time for meetings with my lawyer and court proceedings. For many years, he did not uphold his part of the custody agreement. He did not take his visitation, and if he did, my son experienced abuse and neglect. He did not participate in any school activities, sports, or medical appointments, despite always being notified. He also did not pay his child support obligation. If I ever mentioned a desire to change the order to reflect reality, the harassment and threats would begin immediately. Ultimately, I decided it was safer and healthier for my son and I if I did not engage and just left things as they were. As years passed, he became more and more disconnected from my son, eventually moving out of state without notice in January 2019. Only then did I feel safe enough to file for sole custody of my son and attempt to start adoption proceedings. In November 2020, my son's adoption by my husband was finalized. However, this was not the end of my court involvement. I am still in active litigation regarding my son's visitation with his paternal grandparent who participated in our abuse. While most of my experiences fall outside the scope of H45, they have helped me recognize the need for this legislation. I now have a lawyer who understands my situation and the emotional toll this process takes on myself and my family. I am deeply grateful that he is able to offer me some protection by filtering what I need to see and when. Prior to being able to afford my current counsel, I spent many years afraid to check my own email, never knowing when there would be new contact directly from my abuser or a new legal filing. Any contact I have with my abuser risks triggering my PTSD and further reduces my ability to emotionally heal and move forward in my life. Additionally, the inability to truly be free from my abuser removes the possibility of closure. The financial consequences of ongoing and seemingly never-ending court cases is absolutely devastating. Over the past 12 years, my husband and I have spent over $40,000 and we are still accruing legal fees. I wonder how different my son's life would be if we had the opportunity to spend this money in a more positive way instead of continuing to fight for our safety and protection. The consequences to victims of ongoing litigation abuse are vast, deeply disconcerting, and uniquely discouraging. Even years after climbing my way back from homelessness, job loss, and poverty, I'm still vulnerable to all of those hardships because of the ongoing financial burden. I know I'm not alone in my experience. The laws as they stand enable abusers to continue to harm their victims within the judicial system. Ironically, this is the very same system that also purports to protect survivors. I believe this bill is a much needed step forward in truly protecting survivors in a meaningful, ongoing way. Specifically, provision 2B4 on page 5, allowing for a survivor to verbally request an order restricting abusive litigation in a hearing is an important step for accessibility. It removes the barrier of a survivor needing to figure out the additional steps needed to file paperwork. No filing fee is also another important feature of this legislation. Finally, I want to highlight the provision in 1184B2 that allows the awarding of attorney fees. This will have an inherently protective impact for victims and restore a sense of financial justice. It could also act as a deterrent, discouraging abusers from using abusive litigation tactics. H45 acknowledges that abuse doesn't end when the victim leaves, and that the judicial system is often used as a tool of harm. It recognizes that the work that still needs to be done to protect fellow Vermonters, and it takes meaningful steps forward in that process. Support for this legislation signals hope to current and future survivors that the judicial system can and will protect them after they leave their abuser. It is a positive step towards restoring lost trust from a system that has fallen short in protecting survivors. Support for this bill shows humility and humanity. I want better for my fellow Vermonters. I appreciate your time listening to my testimony today and for your consideration of my perspective as a survivor. I hope you will support H45 to help protect all survivors from further harm by litigation.
Thank you. Are there any questions? Thank you so much. Oh, one second.
Thank you for being here. In listening to your testimony and whatever else, is there anything else you'd like to see in this bill for all the discussion you've been having with all your support staff and attorneys? Is there anything missing? And if not, that's fine. I'm not trying to put you on the spot.
Yeah, no, I think this is a good start, a good foundation. I think trying to do too much with it would just not be as effective.
Thank you so much for your testimony. Thank you for coming here this morning.
Yeah.
We do appreciate it.
Having me.
Yes, Senator Bruce.
I'm looking at, and thank you so much. I'm looking at page 2. This testimony sort of brought this out for me.
Which page?
Of H45.
Yep.
So page 2, down middle of the page, it's 3. The litigation is being initiated, advanced, or continued primarily for the purpose of abusing, threatening, blah, blah, blah. It's reminding me of the hate crime statute where it was, you had to prove that it was done completely, and then we changed it to whole or in part because nobody could prove.
Right.
It seems like we're going to have the same problem here because, yeah,
I agree.
in the witness's testimony, I would imagine the other person would say, I was doing it because I wanted access to my child.
Right.
So there's always going to be an excuse, and primarily would be tough to prove.
Yeah. I agree.
I agree too.
I think that is problematic. Same as with the hate crime.
Yeah,
I just don't remember what we did with the hate crime.
we said whole or in part.
Whole or in part. Michelle, did you get that?
I did, but I think you have to be a little careful here. I mean, you look to the factors where that the court's going to weigh in determining whether or not it is being filed primarily for those purposes. Now, remember, when you're talking about, obviously, about parental rights and responsibilities, you're implicating a parent's constitutional right to care and control of their child. And, you know, I'm happy to chat with Judge Zone about that, but I hear your concern there. I guess I would just say I am not sure you want to back off of that standard in that
We
circumstance.
could certainly talk about that during markup, but I think proving primarily would be difficult.
It is a preponderance of the evidence standard. So you have to put all of those things together. So it has to be shown that it's primarily for the purpose of harassing the victim. And then you have that list of things that the court can look to in making a determination of whether or not the court believes that the primary purpose, it could have multiple purposes. So it could be that the petitioner is doing looking for a modification of a parental rights and responsibilities order. And that access to the child could be part of that, but then the court could look at and say, yeah, but you haven't shown up and taken your child on the weekends that you're allowed to have that child now, and then they take all that stuff into consideration. I think maybe having Judge Zone come back and talk to you about how a court might move through those standards might be
Why
helpful.
don't we take this up during markup? I want to make sure we have time to hear from Jennifer, who's on Zoom. And want to remain anonymous, which is fine.
Thank you so much for the opportunity to share my story. My name is Jennifer and I live in Norwich, Vermont. My family's lived in Vermont for 7 generations, and I really hope that this testimony will help encourage you to help my family here and now so that this generation and the next can be protected from abusive litigation. My story begins 6 years ago when I separated from my former spouse after domestic violence. We share together a beautiful daughter who is 7. My former spouse was arrested and he was criminally charged with domestic assault. I was then granted an emergency relief from abuse order, and I did then pursue a final relief from abuse order that was granted for an additional year. My former spouse, he was released from jail with conditions that then mirrored the relief from abuse. Over the course of the next 2 years, my former spouse filed one continuance after another in his criminal case, and he changed his lawyer 3 times, prolonging the outcome and forcing me to have contact with him, miss time from work, and prevent my ability to heal emotionally. He also made me fear for my right to privacy when he subpoenaed my medical records. The subpoena was denied, yet that fear lingers even to today. He will go to great lengths to seek to invade my privacy long after our divorce. To reach closure, the state's attorney offered my former spouse a plea for a lesser charge, a misdemeanor for disturbing the peace. He received probation for 12 months, and the plea was finalized and the conviction has since been expunged. During our divorce, each of us was represented by competent counsel. We had a 2.5-day contested hearing. It was awful. And then the judge entered a final order and a parenting plan that totaled 33 pages. The order entered 5 years ago granted me legal and physical custody of our daughter with a shared 50-50 equal visitation. The order entered 5 years ago is still in effect in its original state today, and I really want to underscore that. I really want you to keep that in your mind as I walk you through what's occurred since our final order 5 years ago. My former spouse now acts as a pro se litigant, and he's filed over 100 motions in multiple courts. And with every motion that he files, I'm forced to defend myself. I lose precious time with our daughter. I lose a lot of time at work to meet with my lawyers and attend court. I've spent tens of thousands of dollars in legal fees, and I'm re-traumatized over and over again in my attempt to reach a dream, and it's a really simple dream. I just want our daughter and I to live our lives free from abuse. My former spouse has continuously attempted to relitigate issues that have already been decided by the court. These motions, they're not about winning. They're not about justice. He's even delayed his own court proceedings as long as possible, repeatedly seeking continuances to prolong power and control over me and deplete me financially and emotionally. And when he ultimately reaches an unfavorable ruling, he begins all over again, bringing similar or parallel litigation in another court. Here are a few examples of the litigation abuse I've experienced. He appealed our divorce with the Vermont Supreme Court twice, denied. He appealed our divorce again with the United States Supreme Court with a petition for writ of certiorari, twice denied. He filed a federal civil lawsuit against me, making meritless claims of 4th, 5th, and 14th Amendment violations, malicious prosecution and abuse of process, fraud, slander, libel, and other meritless claims. This too was denied, and he has since appealed twice. For this reason, I'm not using my last name, and I'm keeping my camera off because I do fear I will be subjected to another civil lawsuit if he learns of my testimony. My attorney, who has more than 30 years of experience, has shared with me he often sees high conflict families with court case summaries totaling 3 pages. Our case summary totals over 40 pages in the Vermont Superior Court alone. My former spouse has appealed and filed for reconsiderations in almost every instance. He's filed more than 115 motions across 4 different jurisdictions, from Vermont Superior Court Family Division to the United States Supreme Court. He files repeated motions to overturn the court's decisions on child custody, the parenting plan, contempt motions, frivolous motions, appeals, and motions for reconsiderations. He persistently and habitually files motions without grounds. Vacations, birthdays, funerals, holidays, every single moment of our life is impacted by abusive litigation. On Christmas Eve in 2022, I learned he filed 12 motions for appeals and reconsiderations in Vermont Superior Court in a single day. And you may be asking yourself, is this just another high conflict couple, each filing equally in the court? No, it's not at all. I've tried mediation to reduce the conflict and come up with resolutions. The courts also appointed a parent coordinator, which I supported, yet he refused. Instead, he filed 30 more motions for appeals and reconsiderations. I strongly believe he doesn't want resolutions. He wants to rule me. Without merit and as retaliation, my former spouse continuously seeks primary custody of our daughter. He targets my one vulnerability, our child, to maintain power and control over me. He repeatedly portrays himself as a victim, seeking to overturn the court's decision granting me legal and physical custody of our child. Twice, he has sought relief from abuse orders, falsely portraying himself as the victim of domestic violence, seeking protection for himself and our child from me. These have both been denied. I live in fear each and every day that I will be continuously served legal papers and be forced to appear in court to maintain legal custody of our child. I have to keep diligent records of our entire lives to protect us. Our daughter is 7, and she's been in therapy for the past 5 years. Our child suffers with post-traumatic stress disorder, anxiety, and anger. The chronic stress impacts her health and her ability to function in school, both academically and socially. And like our daughter, I too suffer. The fear, the anxiety, the stress, the hopelessness from this chronic harassment and abuse has crushed me physically and mentally. My former spouse seeks to control us, destroy our relationships, and isolate us from any support network. He brought a civil lawsuit against our child's longstanding therapist in an effort to intimidate her, have her withdraw care, and isolate our child from emotional support. This lawsuit was once denied, and he has appealed. He seeks to also intimidate our family members from supporting us and destroy positive relationships in our child's life. He has sought relief from abuse orders from our child's loving grandparents by, again, falsely portraying himself as a victim of domestic violence, seeking protection for himself and our child from them, her own grandparents. This too was denied. I am also fearful to begin any loving relationship with a new partner. I fear my former spouse would also target and falsely accuse a new partner. He has threatened my attorneys with bar complaints to intimidate them from continuing to represent me. And he also repeatedly contacts my attorneys to harass and increase my legal fees. And he also abuses the discovery process by demanding excessive discovery, causing me to take time off of work and miss quality time with our child to gather and compile the excessive documentation. My life is constantly protecting myself from abusive litigation. And abusive litigation is financially devastating, especially following a crushing divorce. The high cost of legal expenses following the divorce alone led me to sell our home to pay back more than $60,000 in legal expenses. And since the final order 5 years ago, I've spent even more, another $75,000 in legal expenses to defend myself from his relentless pro se filings. And every year, our towering case file, it moves to a new judge. Judicial rotation means within 6 years, we've had 6 different judges in family court. Every single year, we seem to start from scratch with a new judge. We try to convey this is a case in crisis. Our family's in crisis, and our daughter's well-being is at risk. Idealized co-parenting from the courts ignores the realities of domestic abuse and how it doesn't end when the divorce papers are signed. He has just changed the tactics, and defending myself from his relentless pro se motions, the judge defines that my abuser and I are still equally high conflict, essentially permitting the abuse to continue. And judicial leniency with pro se litigants is evident. And it occurs at my financial and my emotional expense, all while refusing to recognize the legal authority of the court system and the decisions that have been made. I have never been awarded any kind of relief in the form of legal expenses or sanctions. There has been no acknowledgement of his malicious and intentional lies under oath by the court with penalties of perjury. My former spouse has attempted to have a judge disqualified from a case after receiving an unfavorable ruling. He has also filed motions to recuse a second judge after an unfavorable ruling. This was twice denied by the chief superior judge. And he has also filed an official judicial misconduct complaint against that same judge. And let's not forget, my former spouse is a pro se litigant, unless the consequences become too great for him. With every motion he writes and every cross-examination he makes, it's him confronting me on the stand with questions, again, forcing more contact. 5 years ago, our divorce was finalized, yet nothing and everything has changed. Our final order and parenting plan issued 5 years ago is in its original form, still in effect, including his 50% visitation, while abusive litigation has overtaken our entire lives. Any action I take in my life can have severe consequences, leading to my former spouse filing yet another legal action. The courts that I believed would provide me and our child protection are a weapon that my former spouse uses against me to destroy me psychologically, emotionally, and financially. Every moment I live in fear of what motion will come next. And I hope today you hear this fear. We need help, and we need a change to the law to protect our lives from abusive litigation. Abusive litigation by my former spouse is an unmistakable example of domestic abuse and misuse of the courts. He has intentionally and recklessly misused the courts to exert power and control over me, punish me for leaving him, and emotionally and financially ruin me with complete disregard for the harmful effects on our daughter. Our daughter is 7 this year, and it pains me how little progress I've been able to make over the past 6 years to protect her and myself, despite my pleas to a bench of capable and intelligent adults. What this bill would mean to me is hope that the courts can rebuild integrity and trust with the communities that they serve. And with judicial training and application of this bill, my life would change for the better. My daughter's life would change for the better. And I really hope that you will carefully consider this bill and the positive difference it will make for Vermont children and survivors like me. And then lastly, I just want to also thank from the bottom of my heart, friends, families, lawyers, medical providers, teachers, and our child's therapists, who all continue to help me and our daughter knowingly at great personal risk and personal expense to themselves. Thank you for considering this bill.
Thank you, Jennifer. We appreciate your testimony. It's very helpful. Both you and Brianna put a personal face to this problem and why we need to have some legislation. Are there any questions for Jennifer? Jennifer, thanks so much. We're going to take a 10-minute break for 20 minutes, not quite 10 minutes, but till 20 minutes, 12 to 11.